It is so nice to have a class with people here. I appreciate the brave few who attended the class on Friday and on Sunday. I've heard from probably about half of you who've watched the videos. What I said in class last week was, as long as you watch the video and you email me to verify within a week of the class, I'll mark you present. So I still need to hear from half of you. Okay? I'll leave this on for a few more seconds. The reason why these videos are important and just not getting notes from your friends is I try to give you stuff that isn't in the book. So I think you'll find that by watching these, you'll be in a much better position. I'll try to be as accessible as I can. You got the walkie-talkie?
Yeah.
No, it doesn't fit in the chair. All right. I'm going to turn this off. If you're here and you didn't mark yourself present, you can go to it after class and talk to me after class. I want to start you off with a question that I think will provide a refresher from last week, or I guess from last class, and also provide a segue to our class for today. So this is going to be your question to lead off class today. It's not true or false, we have to a little bit more work. A, B, C, D, E. Okay? The question is this. Adams, who owns Wet Acre and Dry Acre, conveys Wet Acre to Betsy, but Adam retains the right to use the lake on Wet Acre. And I'm using Wet Acre and Dry Acre rather than Black Acre and White Acre because it makes it a little bit more obvious what I'm talking about. So the question is, what is a dominant estate? Adam, Betsy, Wet Acre, Dry Acre, none of the above. I'll give it another 30 seconds or so. Okay. All right. About 40 of you voted. I'll stop it in a minute. I have no idea where I finished off last time. Does anyone remember? You remember? Oh, are you next or she next?
I'm next.
See, that's the honesty I love. Because usually people throw their neighbor under the bus. So, Taylor, I appreciate your candor. What did you put for this question?
I put Dry Acre.
Okay, you put Dry Acre is the dominant tenant. Why'd you put Dry Acre?
Because I know that they're not the ones serving, so they're not serving.
Okay.
But I don't know how to do it.
Okay.
I put Dry Acre also because I know it has to be a property, but then I'm not sure.
So you're saying the dominant estate has to be a property and not a what?
A person.
Ah, okay. And what did you put?
I also put Dry Acre. So the same reason it's not a person, it's supposed to be property, and if it's the dominant one, I guess it's being benefited by the access to the other property.
So because Dry Acre is benefiting from it because there's access to Wet Acre, that's the dominant estate. Right? What did you put?
I put Dry Acre because I figured it was like the principal estate, if you will.
Okay.
So Wet Acre, being able to use Wet Acre was kind of like less, so it wouldn't be dominant and wouldn't be principal.
All right. Did anyone put anything other than Dry Acre? Oh, you're next. What do you put?
Well, I put White Acre to still retain the right, but that was
Okay. Alex, did you put the same?
I did the same as Cindy, yeah.
I put none of the above.
You put none of the above. Why put none of the above?
Because it's a gross.
Oh, you're right. She's right. It was a trick question. How many of you put Dry Acre? Yeah, I put you none of the above. Okay. None of the above is right. Let's see the results. Okay. Yeah. So, but this question though is good for a couple reasons. About 8 of you put none of the above. What do we put on? So let's go through these one at a time, right? So the first thing you should realize, right? And I think either Elaine or Emma said this correctly. When we're talking about dominant estates, I'm asking about a piece of property, not a name. Okay? When I'm talking about a dominant or a servient estate, I'm asking you about black acre, white acre, wet acre, dry acre. I'm not asking about Adam or Betsy. So those of you who put A or B, about 10 of you, right off the bat, that's not right. Okay? Now, the harder question has to do with what kind of easement we're talking about. Now, look how I framed the question, right? Look how I framed it. I said, Adam owns wet acre and dry acre. He conveys wet acre to Betsy, but Adam retains the right to use a lake on west acre. Right? So, Valerie, I think you can finish it up. Who's benefiting from here? Is it Adam or the owner of dry acre? Right, Adam. Adam happens to be the owner of dry acre at this moment, but that doesn't have to be fixed, right? Because even if Adam sells dry acre to someone else, he, Adam, still has the benefit. Everyone see that? This is what we call an easement in gross. The definition of an easement in gross is that the benefit goes to a person, a specific person. Doesn't matter where he lives. So Adam can move around, but he always will retain the easement in gross. So here's the rule we discussed with 3 of you in class on Sunday, right? With an easement in gross, there is no dominant estate, right? With the easement in gross, there is no dominant tenement. Why? It's in a person, right? It's in a person, and that person's name is Adam. There is a servient tenement, right? The servient tenement is wet acre. In this question I asked right over here, if I ask you what's a servient estate, it's wet acre. That's easy. Because wet acre is serving, it's providing the water. But there is no dominant estate. Okay, this is an easement in gross. There is no dominant tenement. So it's sort of a trick question, but I did it quite deliberately. The answer is E, all the above. I'm none of the above. David?
What if he had transferred, dry acre to somebody else with the easement, then would that make it an easement after?
So let me rephrase the question differently, okay? Let me answer David's question. I'll turn this off now. Okay, but most of you got that one wrong, which is not bad, but watch the video. That's why I have to watch it. What if I say, Adam retains the right for the owner of dry acre, right? I changed this, right? I added this new language. Adam, who owns wet acre and dry acre, conveys wet acre to Betsy. But Adam retains the right for the owner of dry acre to use the lake on wet acre. Now, Natalie, what kind of easement is that?
If Adam retains the right.
For the owner of dry acre, how would we characterize this easement now? It's not an easement in gross. What is it?
An easement after tenant.
Yes, exactly right. So here, it's an easement appurtenant, right? And Natalie, what's an easement appurtenant?
The benefit of the easement belongs to the owner.
Yes, the owner of the property, right? With an easement appurtenant, the benefit goes to whoever owns the property at a given moment. So we break it down, right? Philip, in this case, let's do it first. Which is a servient estate, Philip, in this second question I framed? Which one's servient?
Is it still wet acre?
Which one is serving? Say it again.
Wet acre?
That's right. Wet acre is serving. Why? It's serving. It's providing the water. And finish up, Phil. Which one's the dominant estate?
Dry acre.
Yes. Exactly. Right? The dominant estate is dry acre. And everyone sees why. Because here the benefit is going to a owner of land. It's an easement appurtenant, not an easement in gross. And with an easement appurtenant, you have both. You have the dominant estate and you have the servient estate. The servient estate is doing the serving. The dominant estate is dominating. Okay? So don't get tripped up on that, right? So this question, let me go back up to the question at the top. I was trying to trick you on two things, and most of you fell for either one or the other, right? The first thing I tricked you on is, when I'm asking for a dominant estate and serving estate, I don't want to name of a person. Don't give me Adam, don't give me Betsy. But 10 of you did that, that's wrong. Give me the name of a property. But that's not enough. You have to say, do we deal here with an easement appurtenant or an easement in gross? If it's in gross, there is no dominant, right? Only servient. But, and this was David's question, second, If I change it up and I make an easement after tenant, you got both of them. Okay? Everyone see that? Yes, Sir Isaac.
Can you make an easement with regards to a corporate person?
Yeah. But believe it or not, my friends, I believe in the common law every once in a while. Corporations are people in all aspects of the law. Property as well. So absolutely. Long before Citizens United, corporations had rights as persons to own property. Long before. You can create to a trust, a partnership, whatever you wish. But the problem with that, and I'll take Isaac's question well, what if the corporation dissolves, right? What if the corporation ceases to exist and the easement goes away? The downside to an easement in gross, right, is that it's in one particular person. Whereas this once in a piece of land, it's fixed to that land, whoever owns it at a given point. Now, generally, a person who dies can have their interest inherited. I think if a corporation dissolves, maybe if it's purchased in bankruptcy, I'm not sure that would work, but it's a little bit trickier. Okay. So I'm going to get that first lead-off question, right? Oh, yes, Kelly, please. Yes, you can alienate it. Yeah, I only took Isaac's example to think if a corporation goes bankrupt and dissolves, it's not quite like an inheritance. Whereas if a person dies, their interest can be inherited. But very good question. Everyone see that, right? So what you have to understand about easements, and this is more or less a recapping of our class on, I guess it was on Sunday, lost track of the days at this point. It allows someone to burden another piece of land, right? When you pay for an easement, you are saying, I am going to burden your land. I'm going to commit a trespass, whatever it happens to be. But it's not just me that I'm committing a trespass. It's myself, my heirs, my assignees. This is Caitlin's question, right? I can assign this elsewhere. So the trick to an easement, when you're drafting one, is to make sure that it doesn't just bind the present parties, it has to also bind future parties. Otherwise, it's not very good, because people don't want to buy a piece of land if they can't use it in a certain way otherwise. Okay? So that's easements. We also discussed something called a license. A license is oral permission to use land. Oral. That is, not written, spoken. And you're all familiar with the idea of a license. Why? If you invite a friend over for dinner, or you invite the plumber to your house to fix your toilet, whatever, you're giving this person oral permission to enter your property for some limited purpose. To have dinner, right, to fix your toilet. If that person overstays his welcome, doesn't leave, you can him out and call the cops. Oral licenses can be revoked. A written easement, statute of frauds, cannot be revoked. You can't just say rip up an easement and go away. That doesn't work. Likewise, an oral communication, an oral license, can be revoked. Now, the book includes a couple different questions, right? There are a couple exceptions to this rule, okay? In some cases, fairness comes into play, what we call estoppel. If a court finds that an oral license needs to be enforced as a matter of fairness, the court will continue to enforce it. There's also prescription, which is a synonym for adverse possession, right? It's the same idea. If you continue using a piece of property in a certain way, so you walk across a strip of land every day for a decade, it's done with hostility and a claim of right, the court can actually, you've gained a right to cross it. Now, you don't own it. It's not adverse possession. It's called prescription. So what that means is you've gained an easement. So now when that person sells this piece of land, he doesn't actually have fee simple. He has a property that's fee simple subject to your easement, and he must take it with those restrictions. Make sense? Okay. So any other questions on property, on our last class, Easements II? I tried to recap as best I can. Yes?
If you have an easement after tenant, and there's a benefit to both parties,
How will both parties benefit from it? Like, give me an example, what would be an easement that benefits both parties?
So I was thinking about like farmers and hunters and how like a farmer might grow and let people hunt birds on his property.
Uh-huh.
So we both gain a benefit.
Hunting, and that it gets rid of, varmint, I guess?
Yeah, like without eating.
With New York saying varmint, that's so special, right?
And then they get like food.
Okay, so that's actually a reciprocal benefit, right? So you're saying they're both benefiting from it. So you're asking who's dominant in Serbia? I think they both are in both respects. Because I mean, imagine, I'll change your hypothetical a little bit. Imagine that it's no longer owned by a farmer, right? And let's say they make a factory there. At that point, they couldn't care less about the animals. Until these guys were shooting on their property. That would be problematic. So you probably have to draft that as two conveyances, right? One that says, we're allowed to farm here, we're allowed to hunt here, and then maybe another one saying, we are allowing you to, clean up our varmint, so to speak. So it probably works in the hypothetical you gave, but imagine as time progresses, when you're a factory or into a farm, you may not want people shooting up your land. I think that's a reasonable restriction. Yes, sir.
Is the state of mind requirement different between prescription and adverse possession?
Same. Yeah, whatever the jurisdiction is, wherever the claim of right is, that's the state of mind. So the standards are basically the same. I don't have to teach it again. It's the same idea. In fact, the notes after today's reading include the Rockefeller Center example, which I think I mentioned in the first week of class way back when. So you see, I'm not making stuff up. It actually comes later in the book. Anything else? All right, let's move on to today's topic then. Today's topic focuses on what happens when an easement is not written down. Right? Last week we discussed what happens when you have an easement that is written down. Today it's when you have no written down easement. This is not a license. This is not oral. It involves when courts can imply an easement. Right? Implied easements. What? Where am I? Caleb, what does it mean in the law when something is implied? What's this? I mean, saying easements, right? Because you're now lost in some semesters of your belt. What does implied mean?
You look at the surrounding facts and see what is intended.
Okay. Who does the implication here? Okay. Why does a court imply something? Why would a court imply a right?
Because I think that's what's just,
Okay.
what it should have been.
So, someone want to add something?
They're like, as a matter of law.
Oh, God, yeah, thank you. What's a matter of law? What does that mean? Yes, exactly the right phrase. What does it mean, a matter of law?
It's just based on the law.
Who decides what the law is? The judges. Okay, yeah, you're circling back to masculine. Very good, right? So you always see this thing in law, an implied remedy, right? As a matter of law, this is the right answer. What that means is the court says, okay, look, we agree the parties didn't actually draft an easement up for them, but we will pretend they did, right? We will act as if they did, and we will write the easement for them. But there's a consequence when a judge some years later drafts an easement the parties didn't. Chester, what's the problem when a judge, 5, 10 years later, whatever, drafts the easement, which the parties never bargained for, never negotiated for? Why is that problematic?
I guess it gives additional rights that were not there before, or it may bring hardship to the actual owner.
Okay. What are those hardships, Chester? In other words, had the parties known that this easement would have to be done, what would have happened at the outset?
Either a bill probably would have not been made.
Yeah, exactly right. So let's say at the beginning, right? The party said, look, I want to come onto your land to hunt. I want to come into your land to get water, whatever it is, right? There were two options. Okay, pay me or no. Right? Those are options. Either pay me for the option to trespass or go away, I don't like you. But now a judge says, well, this isn't fair. I am going to retroactively write an easement in my judicial pen, right? When a judge writes something, As a fact, well, let me make this point, because some of you may actually clerk for a judge one day, may intern for a judge one day. And I hope you have the same moment I had when I was clerking. Because when you're all in law school, you read opinions, you write memos for legal writing, it's whatever. But when you're a judge and you write something, it actually means something. It has a legal effect. Right? When a judge issues an order and puts his signature, or puts her signature at the bottom, people have to do stuff, right? Someone's life, liberty, or property is affected every time a judge writes something so ordered. So when a judge comes in, years later and says, you know what, it really isn't fair, even though this party never tried to negotiate a deal, I'm going to write it later, that means something. And what does it mean? Chester, I think, said it correctly. It means the value of your property just got diminished, right? You had a fee simple, that's nice. Now you have a fee simple subject to this easement. And when you try to sell it to a third party, you say, oh, by the way, yeah, I own a fee simple. You won't find anything in the records office in the big book, but here's this other judgment, right, that came against me. And this guy, this neighbor, I don't really like him, now he's your problem. Walk away, you're not going to buy it, right? What if you want to build something where the guy's easement is? You can't do it because it's subject to his right. So there's a consequence when judges imply easements, or as Simone said, as a matter of law, they say this, there has to be one here. Now, there are cases where I think it's actually the correct remedy, like when you're landlocked, right? We'll do that a little bit later today. But when you're deciding of how big of a problem you have to have before you imply an easement, think about the dynamics of this diminishes a person's property rights when they were really not at fault, right? They didn't do anything wrong. They're under no obligation to give the guy an easement. They weren't even approached about it in half these cases. But notwithstanding they don't have any fault, they're still on the hook. The one plus side is when judges imply easements, they generally make the person with benefits pay for it, right? They'll order payment saying, okay, you want this easement, pay for it, right? But they still require the owner to engage in the transaction, which is something he may not otherwise want to do. Does that make sense? I just realized my ear popped. It finally popped like 5 days later. I realized it this morning. It just occurred to me while I was teaching that I can hear it normally. So I'm actually very happy because the entire week I was clogged. Anyway, see, I'm actually walking around, not sitting on the chair. So I think I finally feel better. Good. Anything else? So everyone get the general frame. Good. Anyone? Yeah, Jester.
Isn't there like majority minority where like, is it that?
We'll get there. The necessary and strictly necessary? Yeah, I'll get there. We'll get there in a little bit with the Texas case. All right. So there are two kinds of implied easements I want to talk about. Right? There's the easement by necessity and the easement by prescription. Okay. Again, prescription is basically a synonym for adverse possession. Adverse possession refers to taking ownership in fee simple, right? If you squat there for 10 years and there's hostility and claim of rights, open notorious, you get the fee simple, you get the whole thing. Prescription is much more narrow. Prescription is you just gain an easement, right? That is, you gain the right to walk across a piece of land. So, if there's a farm and the only way to get to the road is by walking across this farm, the other way might be an hour out of your way. If you drive across this farm every day for a decade, the owner knows about it, takes no action, you have a claim by prescription. You actually gain an easement, even if you never negotiated for it. You go to a court, and the court will enforce that easement. And now the farm that you are trespassing on has to respect your claim. And here's the key point, my friends. The successors, the heirs of the farmer, they also have to respect your claim. Right? It doesn't go away. Right? The prescription claim stays. I don't want to talk too much about prescription because we discussed adverse possession the first week. The discussions for today primarily focus on the first branch, the easement by necessity. Because this is a lot more, how we put it, mushy, right? With prescription, you have your 4 factors, right? You more or less, you have some case law. But the necessity one, it's based in large measure on fairness, right? Does a judge think that your claim is sufficient to protect that they should chop up a fee simple, right? So let's do the first case. The the Texas case. Yeah, we don't get many Texas cases here. And in fact, usually I say if it's a New Jersey case, they're about to enforce the common law. Texas is the opposite. If there's a Texas case, they're going to do the common law. They're actually going to follow it. And this is what's happening here. I actually checked this case is still good law. There's a yellow flag, but it's on some other ground. So Texas, at least as far as my own research shows, still adheres to this common law rule. Walker, all right, give me the general gist of this case, and I'll give you the chronology in a bit. But what are the general facts here?
So Hill owned a large tract of land. He conveyed multiple pieces to Othen and Rosier, and the way that the tracts of land were conveyed, the only public access road was like the western boundary where the land was conveyed, and Othen's only access to it was through an easement crossing over Rosier's land that they both used. Rosier put a levee over the easement, which rendered like half of the easement unusable. So Othen sued to like join that levee, to get rid of that levee, so he could use the easement.
Okay, good. Okay. So this is a case where a claim for an easement by necessity arose. The publishers of your casebook made this animation, which unfortunately they don't make public, which is annoying, but as a powerful and influential media of the Academy, I have a password for it. So let me show you the chronology, and I think it will illustrate the, I'm being facetious about the powerful and influential part. But I'll show you this animation. So what you have here is a plot called the Tone Survey, almost 2,500 acres, all of which was basically owned by a person named Hill. And there were a couple roads. There was a Beltline Road here, you had Duncanville Road here, and Fish Creek Road there. This is not to scale at all. I'll show you, I took a Google satellite picture of it, but it's like a humongous plot of land. I mean, this is a really big plot of land. They've actually developed, homes, residential, along the top of it. So put this in your notes and just make sure you get the sequence right, okay? So the first transaction was in 1896. Hill sold to Rosier's predecessor in interest 100 acres, okay? To make it easier, I'm just going to say Rosier. There are people who were in between, but trust me on this one. So Hill sold to Rosier 100 acres. If you notice, it's right on the main drag. It's right in the main road, okay? 100 acres, okay? So at this point, Yusuf, right? If you're Hill, is there any problem with you selling this 100 acres to Rosier? Is there any, if you're just Hill, is there any problem there?
No.
Why is there no problem for making the transaction?
For like an easement problem?
Yeah. Why is there no problem? If you're Hill, right? Look at this way. I'll get back to you in a second. If you're Hill, you don't want to box yourself in, right? People are presumed not to be stupid. It's probably not a rational assumption, but generally, not in this room, of course. We're all friends here. But generally, people are not dumb. They're not going to box themselves in, right? So if you're Hill, and this is the only road in effect at the time, you sell 100 acres here. Yusuf, is there any problem with that?
No.
How come?
There's other ways.
Yeah, you can go like this. You go like this, right? You can go up. You can go south, right? There's no problem. So what you have to do with these sorts of questions, if you see an exam or midterm, whatever, is go step by step, right? At each transaction, did Hill do something stupid and block himself in? Okay, so that's the first transaction, right? Okay, then the next transaction. Hill conveyed 60 acres in 1897 to Othen. Right? Again, it was Othen's predecessor, but that it doesn't matter for our purposes. It's Othen. Okay, again, Yusuf. Is there any problem here at this juncture?
No.
Why is there no problem there?
They can still get around both lands.
Okay, very good, very good. Okay? Again, there's no problem. If you're Hill, right? If you're Hill, you can still get around. You go like this, you can go like this, right? You go like this, up here. So you still have multiple means of exiting the property. Okay, what's next? Okay, now the next transaction happens. 1899. 53 acres are sold. Hill sells it again to Othen. So at this point, Othen has this sort of like, backwards L-shaped plot of land, but it's all assembled, right? It's all assembled. By the way, in property law, if you have two pieces of property that are adjacent, even if they're touching each other, they're different properties, right? This always trips people up in the exam. If this is Blackacre and this is Whiteacre, even if they're right next to each other, they're still Blackacre and Whiteacre. You don't merge them. Each property has different rights, different easements, whatever. Keep them separate. Okay? So again, 53 acres. At this point, you have this 103-acre block. Is Hill blocked in? No, he's not. You can still go north or south. Okay, then you have the final one. Okay? Rosier acquires this other block of land, 16 acres in 1899. And you said to finish it up. Is there any difficulty with this last transaction? By this little teal, aqua, whatever color this is. I don't know colors.
No.
No. Yeah. Why is there no problem here, Yusuf? Same, right? There's no obstacle to Hill escaping, right? But the question is, how is Othen supposed to get to the main road? So as things turned out, for many years, Othen basically used a roadway across Rosier's property. Right? It's this little yellow roadway. But the problem arose after there was a flooding. They had to make renovations in the land that made this lane muddy, and it was not passable. Okay? So then Othen sued to enjoin Rosier from interfering with his use of the this cut across. Now, Jared, if you were the lawyer for Othen, what would you advise him to do at the outset when he first moved onto the property years earlier?
I think he talked about the same thing in one of the videos, but make a deal with.
Oh, did I say this last year?
I think he might have said it in one of the
Okay,
videos.
good. Good. Give me what if you were his lawyer, right? You were the lawyer for Othen. What would you have told him when you first moved onto the land at the very beginning?
Talk to Rosier and figure out, hey, I need an easement on that.
Work out a deal, right? Everyone agree? I think he's exactly right. If you're the lawyer for Othen and your guy is moving onto this property, you're saying, uh-oh, I can't access the main road. I'd have to go all the way north, all the way south. That's not fun. And maybe Rosier would have allowed an easement. Maybe he wouldn't. I think the better advice would have been, unless the easement's present, don't buy the lot in the first place. Right? I think your advice is good. This advice is a little bit better.
I think we should have probably talked to Hill about it.
Or say, hey, Mr. Hill, reserve me an easement like this, right? Everyone can see I'm pointing, right? Reserve me an easement along the bottom of the survey. I think it's also good advice. Good lawyers, right? But that didn't happen. Probably didn't even think about it. He said, whatever. This is I'll show you the satellite picture again. It's basically empty farmland, right? Driving across farmlands, whatever. No one even probably cared back in 1898, 1899, whatever. But that didn't happen. So instead, Othen claims to have an implied easement. Right? Now, I want to talk about the implied easement by prescription first and briefly dismiss it, right? They mention this at the end briefly. I don't want to dwell on it. So, John Paul, why is the prescription claim, why does that go nowhere?
Because the use of the easement was limited.
Bingo, right? The first element of adverse possession and prescription is hostility, right? You can't have prescription where it's permissive. If you have permission to drive across the land, right? For all these years, he basically was driving across it and the guy didn't care. You have no claim for prescription. You don't have it. You just don't have a claim for it. It doesn't work. So dismiss prescription quickly, right? I want to focus on the actual lesson for today, which is what Texas applies as far as easement by necessity, right? So, oh, there we go. Sorry, I was lost. Yeah, Jonathan, thank you, sir. How does the Texas Supreme Court approach the doctrine of easement by necessity?
Well, whenever they're talking about it, you kind of have to show that the easement is necessary and like there's no other way.
How necessary do you have to be?
That's to be the only way.
Yeah. Strictly necessary, right? And that's the test in Texas, right? It doesn't just have to be like necessary, it has to be strictly necessary, or maybe I think he said absolutely necessary, or the only way, right? Unless crossing this farm is the only conceivable way that you can exit the property, you're out of luck. Right? You're out of luck. So that's the Texas standard. It has to be strictly necessary. Yeah,
Just
Jesse.
no other way. It doesn't include like, you know, well, you can buy a helicopter and then you're straight.
Oh man, you saw my next example, right? So what if you had a piece of property that's landlocked and the only way to get was a helicopter? That was literally my next example. So either you watch a video or read my mind, right? You did? Good. So what if, see, that's the problem with recording your lectures. You don't like good jokes. It's, you know, people occasionally know my punchline. What if you have a piece of land that's landlocked, right? Can a court require you to get a helicopter? Or what if you have a piece of property that's surrounded by water, right? Surrounded by water on three sides, and there's one way to cross over to the land. And they make you buy a boat. Does a boat maybe better than a helicopter? Cheaper. Or what if, you know, your property is on the edge of a cliff, right? And the only way you get up the cliff is by climbing down a rope or I don't know, a ladder, I don't know, whatever, like, you know, Princess Bride style, right? You know, what are you supposed to do? Right?
No, and don't they talk about like reasonableness? Like
Okay, right. So I think that's Jesse's question. Even though the court says absolutely necessary, I don't think they mean you have to buy a helicopter. I don't think they mean you have to buy a boat or climb up a rope on a cliff or whatever it happens to be, right? I think what they're saying here is, look, guy, you can go north or you can go south. Okay, your commute may be a little bit longer, deal with it. You fail to negotiate for an easement, that's your problem. We, the court, are not going to do it for you. In other words, you should have paid up front to get your easement. You did not do that. Maybe you were lazy, maybe you didn't think about it, maybe you just didn't care. Whatever, your problem. We're not going to retroactively amend your contract to get there. Yusuf.
So what if this person who wants an easement is a wealthy individual who has a boat? Are they going to say that?
Well, I think that affects the reasonableness, doesn't it? Right? If in fact you have a helicopter and you don't want to use it, you're being lazy. You know, maybe this is like, you know, some guy on the island, right, a private island or something. There's a land bridge which he doesn't have an easement to cross. He wants to, you know. So I think the fact is, even though they say absolutely strictly necessary, they're going to factor in stuff like that. Like if the guy actually has a boat, or maybe like, you know, Andre the Giant, maybe you can actually climb up the rope, right? Then that might be a different story. But the rule itself, though, is it's not just what's convenient for you. It's got to be necessary. You're going to hate me. In McCullough v. Maryland, right? The necessary and proper clause, right? Has Marsh read it as what's convenient, what's conducive, not what's absolutely necessary. So Texas uses the James Madison approach, the necessary. Other states use the John Marshall approach, necessary. Don't learn that, but it'll help you in the other class more than it'll help you here. Maybe it'll help you remember McCullough v. Maryland better. Important case. You're doing Connell this semester, right? No. Oh, you did it already. Okay. Well, I never remember. Now you know. So no one was nodding. You should be nodding. All right. So the important points about this case are, first, Texas applies a strictly necessary approach, and second, because Hill never boxed himself in, there's no reason to apply an easement. Had Hill boxed himself in, I mean, we'll do this example in a few minutes, right? We'll do this example in a few minutes. Had he done that, different story, right? We'll get there in a few minutes. But have you're literally blocked in, you can't go anywhere, different story. Okay. Now, the Texas rule, which I think is used in New York and maybe a couple other states, is not the majority rule. The majority rule is the more lenient. Is it necessary in the sense of, is there a hardship? You know, in most states, you can get an easement implied with a lot less evidence. In fact, in most states, I suspect Othen would have won this case, but in Texas, the rule is fairly strict, very rigid, and the courts don't like implying easements, especially where the parties could have done it, but didn't. And again, I checked Westlaw, it's got a yellow flag, but on other grounds, I think it's still good law. Yes, sir, Bradley?
Does the note 2 say the opposite, say that the traditional and still dominant view reflected by Othen?
Oh, did I inverse it? Oh, okay. I'm sorry, you're right. I'm sorry. Thank you for correcting me. Occasionally I invert in heads. So the English rule is in the majority. I erroneously assumed that it wasn't, but I think you're right.
So to make it clear that the
Yeah.
majority...
Yeah, the book's right. I flipped it in my head, which sorry. So the majority rule is the Texas rule, which is the English rule, and my mistake. This is what happens when I try to flush without looking at my notes. Okay. So yeah, note 2 is correct. But in any event, the Texas case is still good law. Thank you. All right. So any questions on the Othen case? Yes, sir.
So if he was using that road and unbeknownst to the owner, the owner didn't know he was using that road and then he created that levy,
Yeah.
we have prescription at that point?
So if it was hostile for like 10 years, yeah, I think you'd have to claim prescription, right? Which is why, and this is actually a good point that Chester raised, if you see some guy that's basically trespassing across your land and you don't really care about it, you don't feel like calling the cops on him, what should you do? What's the smartest thing for you to do? Isaac?
Well, I was going to say, shoot out a bunch of rounds in the air and tell him to get out.
Better idea?
Allow him.
Give him permission. Yeah. So if there's some guy trespassing on your land, crossing over every day to cross the road, and you don't really care, say, hey, I give you permission to do that. At that point, what did you give him?
A license.
Yes, give him a license. And what can you do with a license? Bingo. Perfect. So to Chester's question, right? If a guy is trespassing in your land, the best thing you do is give him permission, because then you can revoke it later, and he can't claim adverse possession on you. You can't claim prescription. The worst thing to do is just sit there and be quiet and not do anything, because at that point, he starts the clock, tick, 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 tick. So yeah, in fact, we're doing beaches later in this class, in a few minutes actually. But sometimes if you ever see a beachfront property, there'll be a sign that says, I give you permission to cross over to the beach. You ever see these signs? Jeff, you seen this sign?
No.
What? No. Has anyone ever seen a sign like this? Yeah, Yusuf, you seen this? Yeah, you'll see this. I was at a wedding a couple years ago in Cleveland, which is right in a lake, and there was this guy's property, and I wanted to see the water, so there was a big sign that said, "Visitors are welcome to cross onto the beach, subject to my revocation," something like that, right? Basically, what they were doing was killing any claims of adverse possession, right? They're saying, "I give you permission to do this, but I reserve the right to revoke it later." That way, if I cross over to the beach every day for a decade on this guy's land, I can't claim anything on it. So it's actually, I think, a smart thing. I don't think I quite realized why that sign was written as it was when I went to that wedding years ago, but now I finally realized it. Hey, Justin.
If Othen did get a prescriptive right to use that easement, and then the flood happened and all of that, and the road was pretty much trashed, would Rosier have a duty to use his own funds to maintain that road for Othen?
Well, that's a good question. So everyone answer this question, right? Let's say he gained an easement by prescription, and the flooding happened and washed away the road. Would Rosier have an obligation to pay to restore? So I think the answer is no, but let me explain why I think the answer is no. The easement is to cross over a specific tract of land, right? There's no obligation the land has a paved road on it, right? So he can still cross over the muddy road. Maybe he's a horse, I don't know, right? Or something else. But I don't think there's any obligation to repair it. The better question is, What if Othen offers to pay money to repair it? Does Rosier have to allow him to do renovations on his property? He may not want a cement road there. Maybe he wants it to be muddy so the water can spill over. That's why he had the ditch there. So I think the easement by prescription would only allow you to use the land to walk. It may not even allow you to use it by car, by horse, right? What if he always walked across his land by foot, and he suddenly wants to bring his pickup truck across it, and his pickup truck makes mud and splashes everywhere? I don't think the easement goes that far. I think the easement only used for walking.
Even if he did drive a truck and that's how he got the prescription.
Well, if he got the easement by driving his truck, that's fine. But the example I used is he walked. Right, it was a 5-minute walk. He only walked it, right? But then if you want to be a truck or a horse, the truck's kicking up mud, making tire skids, right? He's doing, donuts, right? Problematic. They want to see that. Yeah, Jesse.
If you grant a license then revoke it and the person keeps using it, then can they eventually gain easement by prescription?
Well, if you revoke the easement and they keep doing it, you call the cops for trespass, or you do the Isaac approach.
Let's say you just ignore it. I'm saying that then starts.
You start the clock.
Yeah.
The second it's hostile, the clock starts. Or you can do the Isaac approach, like shooting rounds in the air, which.
It doesn't matter if you gave consent and then you revoked it.
Once you revoke the consent, the clock starts ticking. That's the important point. Questions? Yes, ma'am.
In note 2, it also talks about how under the majority rule of strictly necessary, that there was a case where it would have cost $700,000 to build this roadway off a cliff.
Yeah.
Why even in that?
I think that's an extreme example. I mean, I was using the cliff example mostly facetiously, but there may have been circumstances where the person could have actually afforded to build a $700,000 ramp off the cliff. I don't know what you have to do. If you want to pull up the case later, I haven't read that case in particular, but that in my mind is a very extreme example. I mean, it seems almost crazy. But I'll try to defend it, you know, I've read it, right? When you buy a house on a cliff, you should probably know that you're stuck. And then maybe they're just like, you idiot, you bought a house on a cliff knowing you're going to start trespassing. This is your fault. Right? And I think that's different from this case where you actually have flood that changed the terrain. Because when you came here, it was fine. Because the flooding doesn't change the situation. This guy, a cliff has been there for a long time, right? You knew when you bought that the only way of coming down, unless you had a rope, right, is to trespass. So it could have been, and again, if you want to look at the case later and talk to me, but my suspicion is this was you should have known better, right? I can imagine the same thing with water, right? You're surrounded by water on 3 sides. You bought it knowing you have to trespass to get there. So I can see a judge ruling that way. The helicopter one maybe is a little bit extreme, but at least the cliff one is manageable. Yeah, so this video recently for the world's shortest commercial airline flight, and there are these I think it's in Ireland somewhere where they have like a cliff here and a cliff there, and the only way to get across is with a plane. So the plane ride's like 20 seconds long, so they just fly from one side to the other back and forth because there's no way to actually traverse the very craggy, rocky terrain. It's literally like 20-second flight from one side of the cliff to the next. Yeah, Jesse?
I have a question about license. Can a license be implied permission? Like, you don't orally give permission, but you know the person's driving, you've seen them wave or whatever.
Are you saying, so can you understand permission from other circumstances? Like, do you wave the guy and say, yeah, that's fine?
Without saying, yes, you can use this, if it's obvious that you know that I'm using it.
Well, one of the burdens of proof of prescription is you have to show hostility, right? And so then it's actually up to the squatter to show this hostility. And if he can't show it, saying, oh, maybe he sat by quietly but waved me, that'd be evidence that maybe it wasn't hostile. Yes, sir.
Oh yeah, so because in the case they cite Susman and they say that the claimant and others used that easement to present consent.
Yeah.
Is that all true?
Yeah, I think Isaac's rule is probably the right one, right? If someone's trespassing your land, most people reasonably will take steps to exclude the person, and if you're not, you're probably consenting. So I think case by case, you have to look at it. Make sense? Any other questions in this first case? Okay, let's move on. The book notes that even though there was bad blood between the Othens and the Rosiers, at some point decades later, Othen's daughter bumped into the Rosier family and they made up, which I guess is always positive. And the house was ultimately torn down. Let's do question number 3 on page 841. Who am I up to next? Lauren, I think you're next. All right. Actually, the diagram's in 840. Yeah, the diagram's in 840, but the question itself is question number 3 is on 841. You want to read for me, please, Lauren?
A owns 5 adjoining tracts of forest land, numbered 1 through 5. All 5 lots have previously been owned by O as a single tract.
Good.
A purchased each lot from O in a separate transaction. Lot 1 first, lot 2
Good.
second, lot 3 third, lot 3 fourth, and finally lot 5. Lots 1 and 2 are bounded by public roads on the north. Lots 3 and 4 are bounded by a public road on the south. Lot 5 has no access to a public road except for one of the other 4 lots.
Okay, just pause right there. Let me go to the diagram now. So this is not a typical situation, right? We have a property, road, you have 5 lots, okay? The one in the middle is landlocked. Now again, even though they're all owned by the same person, they're 5 separate lots. This is what I mentioned before. If Blackacre and Whiteacre are right next to each other, they connect, you can't merge them, Grayacre, I don't know, right? You can't do that. They're separate pieces of land with different rights, different heirs, different interests on them. You gotta keep them separate, all right? Everyone with me so far? All right, Lauren, want to finish reading the next paragraph, please?
A dies intestate.
Okay, again, and intestate means no will, so you go through the intestacy statute. Good.
Her 5 children, B, C, D, E, and F, are her heirs.
Good.
In the decree of distribution settling A's estate, the court assigns lot 1 to B, 2 to
Good.
C, and so forth.
Okay, good. Yeah, thank you.
Nothing is said in the decree about lot 5 having an easement of way. Sometime later, F sued the owners
Good.
of lots 1 through 4,
Yeah.
claiming an easement by necessity.
Okay,
What
very good.
result?
All right, I'll come back in a second, Lauren, but very good, thank you. So, in this case, F got F'd, as you might say. For the junior child is out of luck. So we have here, number 1 got B. I'm sorry, B got number 1. C got number 2. I'll make sure I get the letters right. D got number 3. E got number 4. And then poor F got number 5. And there's no indication that anyone recognized that poor little F was going to be landlocked and couldn't go anywhere with this piece of land. It was basically worthless. Why is it worthless? You have to trespass to get to it, right? It's literally, people use the word literally wrong all the time. Here, it's literally impossible for F to go anywhere without committing a trespass. And don't think because these are his brothers and sisters are going to help him out. They're not, right? They couldn't care less about him. So F sues his brothers and sisters, right? Lots 1 through 4, the owners. And he claims an easement by necessity. Okay? All right? So what happens here, Lauren?
Well, because it's landlocked and there's no reasonable way to get to the access road, then the courts will have to grant him easement by necessity.
Okay, that's very good. That's the right answer at the end. But I want to talk about an intermediary step, right? So think of it like this. When A dies, his property is divided up in a very specific way. B got 1, right? C got 2, D got 3, and E got 4. At that moment, right? At the moment the property was conveyed, number 4 to D, Justin, at that very moment, what must have happened to 5? Because even though F was dead, his estate still had 5 for that brief moment before it was chopped up, right?
F was dead?
No, A was dead. A was dead, but his estate still owned F. What happened at the exact moment that 4 was given away to someone else? What happened at that exact moment?
I mean, at that point, no one could get to lot 5,
Okay.
right? And I mean, lot 5, F didn't,
Well,
there's no issue.
let me ask the question a different way. Okay. Let's say in his will, let's say he had a will, and A only left 1 through 4. He didn't leave 1 through 5 for anyone, right? What would happen on lot number 5 if it hadn't been disposed of in his will?
It would go to the state. If there's
Well,
no one
eventually to
there.
the state. But what would be the condition on which people take number 5? That's what I'm getting at.
Not really, I'm sorry.
That's it.
Easement.
Implied easement?
Ah, why is an implied easement?
There's no way out.
Yes. Right? That's exactly right. A is not stupid. Again, presume A is not stupid. He's not going to landlock himself in. Courts will say there's no way A would have just kept 5 for himself unless there was an implied easement. Everyone see that? We presume that people are not dumb and they won't lock themselves in. Okay? They will not lock themselves in. Therefore, when 5 is the final remaining property, courts will presume that an easement was implied from 5 across 4. Okay? Okay? We presume that A kept that easement for himself. Now, here's the important point. During A's life, none of this mattered, because he owned the entire lot. But we presume that when A owns 5, he preserved the easement for himself across 4. It was irrelevant during his life, because he can go one way or the other. But once the last one is F standing, and he inherits that property, that easement by necessity comes back in. Yes, sir.
But since F sued all 4 of them,
How do you pick which
there's
one?
no necessity, and if he wins against all 4 of them,
How do you
it's
pick
no
which one,
longer a
right?
necessity.
I'm sorry?
If he wins against all 4, then he has 4 ways out.
Well, then, who would you have sued then?
He sued all 4 of them.
So, are you saying you should have sued someone else?
Just one at a time,
Okay, so you think you should sue them one at a time. What would be the advantage of that?
because then if you lose, then it's still a necessity. If you win, you have to win.
So, I think the reason why I sued all 4, I think your question's good. Well, let me ask you the question. The court says, I agree, there must be easement by necessity. Where do you draw it? Over whose land?
The path of least resistance.
Ah! Oh, beautiful. I have my notes where it does the least damage. That's what I have my notes, right? You draw the path of least resistance. Maybe that's 4, maybe that's 3, maybe it's 1, I don't know. But the court can say, there's a very easy way to get to the road here, but the other 3 are difficult, so number 2, you're screwed. So the reason why I think all 4 of them were sued is he kind of didn't know in advance what the court would think for remedy, right? The remedy wasn't clear. So I think the smart thing is just sue everyone and let the judge figure it out. And indeed here, I think if this goes to court, it's impossible, and they imply an easement by necessity, probably across whichever one's the path of least resistance, or where it does the least damage. And again, you have to pay for it, right? It's not like, number 3 or number 2 are just going to get it for free. They get money for it. But once that easement's there, it's stuck with them. It's on their property, and their heirs and assignees will take it with that easement. Because unlike, flooding, he will always be landlocked no matter what happens. He can never get out. So everyone see that example, right? So we presume that A does not box himself in. He preserved an easement by necessity. Didn't matter while he was alive, right? But when F took it as an inheritance, the court can come back in and apply the easement again over the path of least resistance. Very good. All right, Matt, that's your hand up a minute ago.
Never mind. I'll ask
You
later.
sure?
Yeah. Robert.
On page 835, it talks about the unity of ownership between the dominant and serving estates. How long does that have to be?
I don't know where it is. Oh, here it
All the
is.
way toward the bottom.
835?
Yeah.
835. Oh, that's much further ahead.
No, that was the last case.
Which one?
The last case.
Oh, you're asking from Othen.
Yes.
Oh, okay, I thought you were talking about the notes, okay, yeah, go ahead.
It says to have an implied reservation, an easement created by implied reservation, you have to have unity of ownership between the alleged dominant and serving estates. How, I guess, how
Not
far
sure.
back does it have to have it?
Not
Number
sure.
one? Oh,
So you're reading this passage here, Robert?
yeah. Mhm.
So it says in CJS, Corpus Juris Secundum, my favorite acronyms. It made clear that before an easement can be held to be created by implied reservation, it must be shown that there was a unity of ownership of alleged dominant and serving estates, that the roadway is a necessity, not a mere convenience, and that the necessity exists at the time of the severance of the estates. Okay, so what is your
My
question?
is how far back do you have to prove that there was unity of ownership between those two estates? Just at one point?
I think it's at
owns
one
all of it?
point, and this case is actually fairly easy because we know there was a single owner of the entire lot.
Yeah.
So I think that's a fairly good starting point.
Okay.
Thank you. There's another hand somewhere.
Okay.
Yes, sir.
So you said for easement by necessity, they'd likely just pick the route with the least damage.
I suspect, that's my suspicion.
But if he wanted specifically to go
Oh.
to impose.
Say you wanted to screw over his sister C, right, because she wasn't very nice to him. I don't think the court would oblige that, sort of a spite.
Then he would have to try to get the easement by prescription to continue.
Well, you tried trespassing my sister for a decade, unless you picked out a shotgun called icicles, right? But I think generally the courts don't like creating easements, and they'll only do it where it's the least damage, where it's the least cost of everyone involved. Because I mean, imagine this, right? You're C, right? You inherited this property from your mom, and like you're like, great, and then like the idiot brother comes along and trying to sue you for it, right? No one wants that, so they probably do this in the least burdensome way. Make sense?
Yeah, Mark.
But if you were to sue your sister, like
Yeah, right.
sue C,
That's be one Thanksgiving party, right?
but that was what we were talking about earlier, suing each person individually. Wouldn't they find that there was no, like, this isn't necessary because you
So
could
the
sue-
general rule of thumb is when you're filing a lawsuit is sue everyone and let the judge dismiss them as parties.
Yeah.
Because if you fail to join a party at the outset, you waived it.
Mhm.
So sue everyone, and then let the judge take care of it.
But as this example, if he were only to sue C, would he lose the right to sue anyone else if they considered the fact that
If there's a, I'm hesitant because the statute of limitation does set in, but it would be very inefficient to file 5 separate lawsuits in series. It would not be a smart litigation decision.
Mhm. All right, thank you.
Is there anything else in this example of question number 3? All right, so again, the easement by necessity is going to be drawn across a path of least resistance because people are presumed not to sell land such that they're landlocked. I think that's the general rule. Okay, any question to this? All right, let's go into the beach cases, or case. These would be 2 beach cases. I cut one of them out of the book. I liked the other one much better. This one I didn't like at all. Such as the, in fact, you are the last class that will be using the 8th edition. The 9th edition comes out in January. And it's always bittersweet because, unlike con law, property doesn't really change. I don't know why they need new editions. It doesn't, like, of course money, yeah. But from my, from the 7th edition to the 8th edition, I counted, in your entire book, 3 cases changed. And was it 1,500 page book, 1,400 page book, whatever it is. There were 2 new cases, which I didn't like either of them, and they removed one that I did like, and they made it into a little note case. So, but the flip side is, like, I told the bookstore, can you just like keep getting copies of the old edition? You know, the 7th edition. They said we can't because they basically dry out the market. They don't let the old books for sale. So the problem is, unless I can guarantee there are going to be 90 used books available, I can't use it. So unfortunately, I have to roll with the punches. I can say for a constitutional law book, it's probably 10 or 20% different every 3 years because the Supreme Court's insane. They do always new stuff. But for property, it's been the same for a very long time. So kudos to you. You'll benefit from an old book that will be out of date in 3 months. I haven't even seen this new book. I just know it's coming in January, and I'll have to assign it to my students in the fall or spring. Okay? So any other questions on the, let's do the beach. So you probably don't think much about, oh, someone has your hand up? Okay, thank you. So you probably don't think much about beaches, but there's a significant amount of case law concerning beaches. Okay? Specifically, who owns what? Now, you've all been to a beach, right? Yeah. I don't take anything for granted. There are different parts of a beach. I think this graphic illustrates it well. Let me make this a little bit bigger so you can see it. For different parts of a beach. Okay? So we start with the water, right? Start with the water. Who owns the water? No one. The water in the ocean is considered a public trust. What does it mean, a public trust? It's owned by the public, that is, government, for the benefit of everyone. If you're a fisherman, if you're a navigator, whatever, you have free access to the high seas and people can't stop you. By the way, this is why piracy was such a big problem, because piracy was basically stopping people on the open seas. This is why piracy was a really big deal. Think about pirates, that was one of the biggest problems facing the founders. Okay. But we move on from the water itself to the shore. From the water itself to the shore. Okay? What about right over here where the water meets the shore? Seems like a different color. You know this, right? The wet sand. Right? This is what we call the tide line, where the tide comes in. And what you probably know about the tide line is it varies. You have high tide and you have low tide. So depending the time of the month and the phase of the moon, it can be in different places. What's characteristic, though, about this sort of wet sand is that there's no vegetation, right? There's no plant life. Plant life can't grow because if it tries, it'll just get washed away. You all know this from the beach. Then if you go a little bit further up, you see this sort of like middle ground, right? It's kind of wet, kind of dry. And again, it depends on the tide line. But eventually, if you go up further enough, you come to the dry sand, right? The dry sand, right? This is the point where there's really never going to be water unless there's a storm or something strange. And then eventually, you get to the greens, right? The vegetation line. Where can grass, palm trees, whatever grow? Okay? But that's not the only other issue. How do you get to the beach? You have to cross over property. So you can see here this little dotted green line, right? There's a path from the street down to the water. Okay? It's one thing to say that the water is in a public trust. It's a very different thing to say, how do you get there? So as a general rule, property owners can't stop people from entering, from accessing the water, right? There's not much of a doubt that you can do this, that you can walk straight across a property line onto the ocean. And I think that makes sense. We say that the water is available to everyone, you have to get there, right? If you were able to block this off, and everyone just blocked this off, people couldn't get to the water. It's a problem. But the problem isn't just about accessing the water. And the problem isn't just about being in the water and being on this wet sand. The dispute is this, the dry sand, right? We know people can walk across the dry sand to get to the water. But can people stop on the dry sand? That is, can people put down a towel, folding chairs, right? Beach blankets, and tan and bathe on the water. Now, I created this meme some years ago, and as a Staten Island native, it's a little bit more appropriate. But I think this meme works very well. The basic upshot of the case, this is the cast of Jersey Shore, which was close to my heart as a Staten Islander. Most of them from Staten Island, one even from Jersey, which is the sad truth. Is that the law protects the right to sunbathe and enjoy activities on the beach, right? It's not just you have the right to the water, you have the right to get to the water, and when you get in the water, you can sit there and dry off, right? Now, if this was a public beach, there's really not much of a problem. And indeed, in New Jersey, this is an actual picture of the water. The sand goes a very long distance. And there were a number of public beaches along the way. The only issue was whether this one private beach club could exclude members from the dry sand, right? This wasn't about, do you have to let people into your beach house, the actual property? No. It's the dry sand, that middle region. Are people allowed to go there? Now, this beach club was selective. They only allowed certain people to be members. They charged a fee to go on the sand. So the case here by the New Jersey Supreme Court asks, is there a requirement to allow people onto your dry sand? That's the extent of the decision, I think. So Lindsay, you want to walk us through the facts here, please? And by the way, Lindsay has been our all-star. She came to both of the makeup classes, so give her a round of applause. In fact, on Sunday there was a screw-up. I'll take blame for it. But there was a note on the door saying it wasn't, in this room it was from 414, but the note was not put on this door, it was put on the door across the hallway. So a couple of you were sitting here for about 30 minutes waiting for you to show up. Reasonable. And because there was traffic, it was a bad day on I-10. But for the first half hour, it was just me and Lindsay. Well, I thought it was a good class. So actually, I'm going to skip you. You were good. You did more than enough call. Anthony, you're on call. So but she was very well prepared. So Anthony, what were the facts here?
So the defendant was like I thought it was more like a homeowners association, a beach club. The private homeowners were part of to prevent the public from accessing their beaches where their beach houses were.
Yeah.
And the plaintiffs, the borough of Pleasant Point, filed a lawsuit saying that this property was quasi-public and people should be allowed to cross and come in.
Well, not just cross, but do what? The crossing part wasn't that controversial.
To hang out and
yeah. And I keep showing you this meme, but it's the only way I can explain it well. It wasn't just a cross over the land. That wasn't really in dispute. What was in dispute was the ability to actually spend time on the beach and the sand, the dry sand. The wet sand is public. No one disputes the wet sand. It's the dry sand where the vegetation lives. That's the question. So Anthony, what did the, by the way, this is the New Jersey Supreme Court. What's going to happen here?
They're going to overturn the...
Yeah, you know the answer. I don't need to tell you the facts, right? So what do they do to the common law here, Anthony?
They overrule it.
Yeah, they overrule it. How do they do that?
They say that the public has a right to access this property and to enjoy it.
Good. And is it enough to just have access to the sea?
No.
What additional thing has to happen?
They have to be able to enjoy the property, even though the property owners.
Yeah, exactly. So the holding of the court here, right, is that it's not enough to have what's called lateral access, the ability to go up and down from the street to the water. You need to have the horizontal access as well to actually stay on the beach and enjoy it. And even if it's a private beach club, and even if they usually limit members to certain people, right? So Robert, what's the effect of this? How does this organization need to change their membership policy?
They have to let people go on the dry land.
Can they charge?
No.
No? Can they charge? Yeah. William, can they charge? How much though?
I don't remember. I just remember reading that basically the association had to open up membership to the public.
Okay. So the answer actually is they're allowed to charge, but the government basically sets the rate. And if you don't believe me, if you go to the New Jersey Department of Beaches, I can't remember what it's called, they actually have a chart they put online of the rates for memberships, right? So the government actually sets what the rates are to attend these beaches. And I didn't know this. When I was a kid, I used to go to beaches in New Jersey. I never really paid much attention to it. But we would pay, like, for a day pass, $5, whatever. It wasn't a lot. But with that money, we were able to sit on a really nice beach club property. We couldn't go into the actual club itself, which I never really thought about, but we could only use the sand. So the regime they have now in New Jersey is this. You can have a private club, maybe with showers there, maybe with, a bar, a pool table, whatever, right? You can have a private club past the vegetation line. Past the vegetation line. But the dry sand, that is open to the public for a nominal fee. I think it was like $5. It was not a significant amount. Okay? And specifically, they say that the membership must be open to the public between 10 a.m. and 5 p.m., which is basically the time when you would actually want to be at the beach. The court recognizes some uncertainty with this decision. And they basically say, until this litigation is resolved, the party should have access to the dry sand. And that's the nub of this case, right? That they're required to access this dry sand.
But only certain hours?
Yeah, and it's strange. Why certain hours? Because those are the hours we can sunbathe, right? 10:30 to 5:30 is generally beach-going hours. You don't go to the beach at night. It's actually quite dangerous. People go to the beach at night are usually going to get in trouble. It's not a good idea. Yeah, Yusuf.
So nowadays hotels they still allow people on their dry land, but they just
Yes.
put like chairs. Or something.
Oh, well, that's the next question. Very good. Okay. So, are they required to give non-members chairs? Next question. No. Better question. What about lifeguards? Can they say, we will only rescue you if you're a member of the club? I think that will go over Yusuf.
Not very.
Probably not very well, yeah. So if you ever go like to South Beach, Miami, right, you have these like really expensive hotels on the beach. You can go put your towel down there, that's fine. But if you want to get folding, those nice lounge chairs, right, an umbrella, whatever, you gotta be a member of the hotel or a guest. Yeah.
Isn't Texas a lot different? I think Texas over the beach is actually.
What do you mean a lot different? Are you talking about the dry sand?
The whole thing, there's a rolling easement in Texas.
Oh, you have the next question. Did you watch the lecture already? I was going to roll these in 2 minutes. That was my next note. I'll get to like in 2 minutes. All right, let's talk about Texas then, right? Anna, what's a rolling easement?
So there's different things that cause like the vegetation.
So for example, after Hurricane, I think it was it Rita? So after Hurricane Rita, the Galveston shore, right, got all messed up. And let's say the vegetation line was like, I don't know, let's say it was like over here, right? Now let's say after the vegetation line got pushed over here, right? So there's all this new land that is beyond the vegetation line. Who owns it? The public or private owners? What's the answer, Adam?
Well, I think there's different things actually, but I think the point of the rolling easement is that the public can own this.
Well, let me explain like this. There was a decision by the Supreme Court of Texas called Severance. I'll type it for you. Severance v. Patterson. I think it was, check me the year, maybe 2013 or 2014. I can't remember. It's the last couple of years. And the question is this. Because of Hurricane Rita, you had this sudden change. Oh, by the way, terms you should know. Can anyone tell me the difference between accretion and avulsion? I hope someone can tell me the difference. Please. What's accretion? What's avulsion? These are one of my favorite words in law. Followed closely by flotsam and jetsam.
Small changes and large changes.
Yeah, you want it, William?
Well, I was going with accretion being the gaining of land by small bits.
Good. Okay. So accretion is a general phrase that means slow change, right? And avulsion refers to a rapid change, right? So I think you're both right. So let's say that gradually over the course of a century, due to tides, the vegetation line shifts maybe an inch every 5 years, right? That's accretion. And when there's accretion, nothing really happens. We don't really care about it. But avulsion is like Hurricane Rita or Hurricane Harvey, right? And there's a sudden, very dramatic change in the shoreline, right? Where the vegetation line was here and moves up 5 feet, like in a single weekend of rain. Okay. With all this new wet sand, right? All this new land is now wet. does the government gain ownership of it automatically? That is, does the government gain what's called a rolling easement, as I think was Ann alluded to? And the holding of the court, right, is that there's no rolling easement. Okay? Okay? Under Texas law, there's not an automatic easement. The mere fact that your vegetation line changed following this hurricane doesn't mean the government gets some new property, this new wet sand. You still own it. And what does that mean? If the government wants it from you, what do they have to do? Say it, William? Right, William? Buy it. They got to pay you for it. The government wants this new wet sand. They got to pay you for it. What's called adverse possession, eminent domain. I'm sorry, not adverse possession. They got to use eminent domain to seize it from you and pay you for it. Market value. And this was a huge case because under the Texas Open Beach Act, which Anna referenced, Texas claimed basically the ownership of all this land in Galveston that previously belonged to private citizens. This was a massive case worth probably billions of dollars. This is a really high-profile case. Okay? The Supreme Court of Texas said, no, Texas, if you want the land, you got to buy it. The mere fact that this changed overnight because of this storm doesn't mean the state gets it. You have to use power of eminent domain. In fact, one second. In fact, we'll be having a guest lecture later in the semester on regulatory takings by Justice Brett Busby. He's a lawyer, well, he was a lawyer on this case. He now is a judge in the 14th Court of Appeals here in Houston. He will be giving you a guest lecture on the takings doctrine, and he always mentions this case because this was in his practice. So we'll do much more on the severance case later this term, but I'm glad you brought it up.
Isn't slow change the accretion?
Yes.
As part of the law?
Yeah, right. If there's a slow change, right, a couple inches every decade, the government can't gain that automatically, right? Because no one's really going to care if, like, you live into your property, but we're talking like 10, 20 feet of new sand was put in. That's a big deal. Because imagine you had, like, I don't know, a backyard patio, right, that was on your dry land, and now your backyard patio is on wetland. The government says, oh, that's mine. You just lost your patio. So that's why you have this litigation over this new found land. With water, right? Water comes and goes, so the law has to develop different doctrines to deal with it. Okay? Everyone with me so far? Any questions on the beach doctrine? All right, let me wrap up a bit. The rule with easements in general is that you should write them down. And if you don't write them down, you better hope the court finds your case sympathetic. Courts can imply an easement based on necessity, whether actual necessity or strict necessity, or they can imply an easement by prescription. But there's no guarantee they do that. And if you fail to get the easement that you want, you're stuck trespassing or with a worthless piece of property. So it's always beneficial to get these things drafted in advance. I want you to pay very close attention to the readings for next class, the easements number 3, and also even more so easements the following class. Oh, actually, no, the midterm's on the 3rd, so you only have one more class before the midterm. But when you prepare for the next class, I want you to start thinking about how are easements made permanent, right? How are future assignees going to be bound by these easements? I'll mention the midterm briefly. It's on the 3rd. I'll have someone proctoring it, so I will not be here. You should receive by today or tomorrow the information about ExamSoft. If you do not receive it by class on Thursday, you need to tell me. I'll go yell at people. But I emailed and they said you should get it by today or tomorrow. Yes?
With the finally in your syllabus, you said that it's open book.
Whatever you want, same for the midterm. Whatever you want that's printed, no iPad, right? Your notes in your iPad, print them out. But bring whatever paper you want. I don't care. I'll help you. I don't. In fact, if you're sitting here flipping through your notes for 90 minutes, you're doing something very wrong. If you have to actually look at your notes, you're going to probably run out of time. I mean that sincerely. It's not going to help you. Maybe if you forget like the name of a case or something, fine, how to spell it, but more than that, it's not going to do much good for you. But I strongly encourage, I implore you, before Tuesday the 3rd, a week from today, take one of my old midterms. Just take it, 90 minutes, quiet,
grade yourself, you will give yourself such an advantage more than you can even understand. And after the midterms administered, I will get them back to you, I promise you, before November, and we'll have review sessions with each and every one of you. Deal? All right, I'll see you on Thursday. Thank you.